Hi, everybody. I'm attorney Jason McGrath, and this is another installation of Carolina Contracts. We started out this series of arbitration discussions talking about whether your contract has an arbitration clause, whether it should, what that clause can or should contain, et cetera, et cetera. Now we're talking about, as you get further down the road, if there is a dispute and an arbitration, could perhaps come into play. Well, what do you do if the other party has filed a lawsuit in the formal court system? This happens more than you would perhaps expect. You might think that if an arbitration agreement is part of a contract, that an arbitration would be started up instead of a formal full lawsuit. And it seems more often than not that that's not the way it happens. So what will most often happen in my years of experience, decades of experience, I'm getting a little older here, but anyway, is that the other side has filed a formal lawsuit against you. And you're sitting there thinking, well, wait a second, you should have started an arbitration, not a full formal lawsuit. So you look at the contract. The contract says the parties must arbitrate instead of litigating in the formal court system. And so then what you have the option to do, and you shouldn't do this unless you actually do want to arbitrate instead of being, in the formal system for the lawsuit. And there's a lot of pluses and minuses that go along with both of those, decisions or options, I should say. So what you would do though is you would actually go to the other side and say, hey, look, there's an arbitration clause here. And do you agree that we're required to arbitrate? And perhaps you might want to ask them, do you want to arbitrate? Because if both sides don't want to arbitrate, you can just pretty much ignore that and just litigate in the formal court system. But if one side wants to or both does, then what happens is you file a motion with the court and basically say it's either a motion to compel arbitration, meaning the other side doesn't agree to arbitrate, but you have a contractual agreement that says we're going to arbitrate. Typically what the court will do, again, not always, it's very dependent on each case, but the court will look at it and say, hey, there's a valid contract here, or there's a contract here that is valid at least as far as the arbitration agreement. So I am going to put this formal lawsuit on hold. I'm going to stay it, and I'm going to order the parties to go to binding arbitration. Now, if the parties agree to put a hold on the formal lawsuit and go to binding arbitration, which is what happened in my last arbitration, the other side sued. We went to them and said, hey, what are you doing here? There's an arbitration clause. And they said, oh, yeah, you're right. Okay, if you're going to push that arbitration clause, we'll go ahead and we'll do an agreed order, basically. And you go to the court and say, Judge, the parties agree that we should put a hold on this lawsuit and go to arbitration. Judge typically is going to sign that, sometimes even without you having to go in for a personal, in-person court appearance. So that's the way that typically works. If you have a binding, contract with regard to the arbitration clause, even if other parts of the contract are in dispute, you usually will end up in that arbitration by way of court order. So keep that in mind and decide what you want to do. And if you want to go to arbitration, then just file a motion with the court if the other side won't agree.